Good evening, everyone, and thank you so much for joining us for this next session of our virtual student convention. My name is Princess Jefferson, and I am the current Chapters Fellows here at ACS, and I am excited to announce that I will be attending law school this upcoming fall. I am truly honored and most humbled to be able to introduce today's panel discussion on the intersections of environmental and systemic racism on Black and Indigenous communities. As an African American woman born into a low income neighborhood in the south of Houston, Texas, I have been able to see firsthand how both environmental and systemic factors negatively harm marginalized communities, and more so how a lack of resources can cripple those very people and otherwise force them to suffer silently. Specifically, at the height of this pandemic last year, I watched as members of my community and others perish from not having access to basic resources, or as underlying health conditions stemming from environmental factors and a failing health system made them more susceptible to exposure of the virus. Additionally, more recently, having just experienced the negative implications of a winter storm in Houston that our government had been ill-equipped to handle, I, like many others, were forced to go without power, running water, or in worser cases, watched from afar as many Houstonians and neighboring cities fell victim to mortality due to the bitter freeze and carbon monoxide poisoning. Situations such as these have contributed to my desire to study law, which likewise aligns with the very mission this panel seeks to carry out today, which is to both inform and expose the injustices committed against our most vulnerable communities, but also showcase to others how we as a collective have the power to combat these vicious cycles. Environmental racism is one of the least talked about crimes posed against our Black and Indigenous communities, but tonight's panel seeks to shed light where others have chosen to dim it. Thus, it gives me great pleasure to introduce to you the incomparable and truly charismatic Steph, who will serve as the moderator of today's discussion. For those of you who may not know, Steph is currently a law professor at the University of Wisconsin, whose research examines the intersections between environmental, food, and health sciences and administrative law. Steph has a background in chemistry and holds a Juris Doctorate from the Georgetown University Law Center. Prior to teaching, they worked as the editor-in-chief of the International Review for Environmental Strategies, a law clerk to the Honorable Ronald Lee Gilman on the U.S. Court of Appeals for the Sixth Circuit, and an appellate attorney at the U.S. Department of Justice. They also represent Advocacy in federal circuit court and Supreme Court cases, including Massachusetts v. EPA, which is the first climate case brought before the U.S. Supreme Court, and the County of Maui v. Hawaii Wildlife Fund, which is a recent case in which they co-authored an amicus curiae brief was cited. From 2013 to 2014, Professor served as a Supreme Court Fellow and as a researcher in the Federal Judicial Center. Without further ado, it is with great pleasure that I turn things over to Steph to help us move along with our programming. Thank you.
Thank you very much for that very kind introduction. I'm really grateful for being here. I want to first quickly introduce our speakers and then provide some sort of framing context for the discussion that you're going to be hearing today. So we're first going to hear from Rebecca Tsosie, who's the Regents Professor of Law and Faculty Co-Chair of the Indigenous Peoples Law and Policy Program at the University of Arizona Law. She'll be talking about Indigenous sovereignty and the governance of natural resources after the Supreme Court decision in McGirt last summer. You might not have remembered this, or maybe you're not familiar with this decision, but this was a decision about Indigenous people's rights in Oklahoma, and it's likely to have very long standing impacts in about the governance of Indian country. And I'm very excited to hear this talk. Next, we're going to hear from Selena Kyle, who's a senior attorney and managing litigator at the Chicago Office of the Natural Resources Defense Council. She'll be discussing the environmental impact litigation work that she does. And this too, for you all who are students or law students to be, you're going to find out some really exciting stuff that lawyers can do to sort of have not just the sort of impact of representing individuals, right? But impact litigation is the idea that litigation can be used to achieve structural change. And then finally, we're going to hear from Heejin Huang, who is a staff attorney at the Lone Star Legal Aid. And she's going to be talking about environmental justice and critical race theory on the ground through the lens of work that her legal aid office is accomplishing on the ground, both work that she's doing and then other people in her office are doing, and then relate this to sort of more theoretical lenses about how we can look at legal structures through a critical race lens that evaluates not only what the law is on the books, but how those laws can have disparate impacts themselves on different races, and also reflect a lot of different kinds of preconceptions or possibly biases that are embedded in the law. So I expect all of these talks to be really exciting and that everyone can learn from them. Before I turn things over to our first speaker, Professor Tsosie, I just wanted to provide some general framing for this conversation and to reflect on how honored I am to be able to moderate this really exciting and wonderful panel. So I'm really grateful to be able to present on this and to be asked to present on this because environmental justice has been a longstanding concern of mine, both as just a human being, but also as someone who is interested in researching in this area. Sort of part of my past was I came to environmental issues, not from sort of personal exposure to them, but from my background as a chemist. I was fortunate enough to work for someone in college who ended up winning the Nobel Prize in co-sharing the Nobel Prize in chemistry for discovering the ozone hole and the processes that led to that. One of the things that was fortunate was not just the fact that I got to work for a Nobel Prize winner, but that was the first Mexican American to win the Nobel Prize. And he donated his money entirely to sort of environmental justice issues in Mexico City. And so there's a very personal aspect of environmental justice to me that stems from my whole scientific background. And he long instilled this kind of concern way before I became an attorney in the sort of impacts that environmental concerns can have in terms of disparate impacts on racial minorities. So I've been studying things like the EPA's use of environmental justice discretion in the context of permitting, agent environmental justice and the development of brownfields, working with Hmong and indigenous communities in Wisconsin. And then recently I've also, sort of explored some things about environmental justice, both in a broader kind of context, not just environmental justice, but rather systemic racism on the part of federal agencies, and also how environmental injustice and systemic racism can be addressed through community building kind of efforts. So I wanted to sort of talk about that a little bit too later on. But the main thing I wanted to sort of give as a context before we get to all the speakers is just a history of the environmental justice movement and what it really means and how it tackles systemic and even sort of direct racism. So the environmental justice movement, as it's known, rose when individuals, primarily people of color, sought to address the inequity of environmental protection or lack thereof, and that's the main thing, in their communities. And many have traced the roots of this movement to the disparate public health concerns raised by the civil rights movement, including by Martin Luther King Jr. But what is environmental justice, or perhaps what is environmental injustice? The scope extends much beyond what we think of as traditional environmental law. I mean, there are traditional environmental law things that fall corely within what people teach as environmental law 101 in law school, which can range from the water contamination crisis in Flint, Michigan, where high levels of lead in drinking water affected numerous low-income and minority residents. They can include the confined animal feeding operation issues in a number of states, including North Carolina, which led to water contamination issues predominantly affecting low-income and Black communities. They include general problems arising from land toxics contamination. But again, like I said, this can extend beyond traditional environmental law. And I expect what you'll hear today is not just sort of environmental law, sort of traditional issues under the Clean Water Act, Clean Air Act, et cetera, but also things that we don't necessarily think of as traditional environmental law, but affect the environment of many Black and Indigenous communities. That is food sovereignty issues, workplace exposure issues, things that we sometimes characterize in law school as other kinds of areas of law, but are actually environmental injustices. And these all come from areas where the core of environmental law failed to adequately protect Black and Indigenous communities. Now, how do these injustices arise? They arise from a potent mix of historical patterns of institutional racism inadequate protection to environmental protection, and inadequate conception of what the environment is and means for Black and Indigenous communities, and community disempowerment. As scholars have observed, environmental law as written can fail to consider distributional consequences resulting in disproportionate effects. Environmental law can exacerbate existing disparities. They can concentrate environmental harms through these not in my backyard legal efforts, and they can often serve the wealthy better than the poor. And so one of the consistent factors in all of these examples, and we'll hear from our speakers on this, is community disempowerment and systemic racism. That is, these communities suffering from these environmental harms lack the resources, the ability, and the buy-in by the majority to effectively advocate against unjust private and governmental actions. And that means that the tools to address environmental injustice can sometimes extend beyond sort of traditional areas of law, although we will hear about some of the more traditional kinds of legal ways to address it. So we'll hear about impact litigation, which many of you might be familiar with, but we'll also hear about grassroots organizational efforts, support services for affected communities, and what I recently wrote a paper on, scaffolding. That is the use of litigation tools to enhance community self-advocacy efforts. So with that, this framing of this, I hope that you get a better sense of what you'll hear about today, and maybe also structure questions to maybe get at ways in which you might be able to engage with addressing environmental injustices in the future. So with that, I will turn this over to Professor Tsosie.
Thank you so much, Professor Tai. It really is an honor to be part of this amazing panel, and you did a great job in your introduction and laying the framework. Thanks also to Princess for that lovely introduction to our panel. I'm always filled with pride and just, you know, to see those impressive young women and young men out there who are going to take these leadership positions. So to everybody watching this, thank you so much for your hard work. Thank you for your dedication, and thank you for being part of this amazing event. We thought that we would do this kind of in a roundtable format, so I'm going to keep my comments relatively brief, but I'm going to talk about some issues that certainly we can go into in Q&A if you're interested. So I am speaking to you from Arizona. Our campus of the University of Arizona is on the traditional homeland of the Tohono Nation, and the Pasquayaqui Nation is right next to us. And to me, it's very important to acknowledge those traditional relationships between Indigenous peoples and the land. And that really is the framework for environmental justice. Because we have to talk about justice before we can talk about injustice. So we talk about environmental justice, it's honoring that relationship between people and land that sustains all of us over time, that we have water, that we have food, that we have health, that we have wellness in every part of our being. That's environmental justice. So what happened? Well, lots of things happened. Colonialism, war. So when the Supreme Court decided the McGirt decision last summer, that held that the Muskogee Creek Reservation that was created by treaty in 1856, and it still exists as a doctrine of US law that established the boundaries of the Creek Reservation, and that had never been disestablished, because only Congress can disestablish a reservation, and they never did. Of course, it was invisible, because even though the Muskogee Creek people were living on their reservation for generations, the state of Oklahoma pretended that it didn't exist at statehood. They took the land that belonged to what, in the opinion, you'll read, the 5 civilized tribes. That is a terminology that the United States used when it removed the Cherokee and Choctaw and Chickasaw and Creek and Seminole nations. It removed them from their traditional lands, which were out in Georgia and in other parts of the Southeast, to Oklahoma, which was going to be Indian territory. And it created the reservations, and it promised each of those tribes This is your land. We will never take it, and the state will never regulate your land. And of course, they forgot their promise. But Justice Gorsuch said that just because the state had acted as though the reservation didn't exist, that was not enough to disestablish it under federal law. That case involved criminal jurisdiction of an Indian on Indian crime in Indian country, which means tribal and federal jurisdiction only, not state jurisdiction. And that was the holding of the case. We could go on, but the implications of the case were huge. Chief Justice Roberts, on behalf of the dissenters, basically said, look, what are we going to do? We have 19 million acres. We have 1.8 million people who didn't know this was the Indian country. And now you're saying this Indian country is going to be a game changer. Well, it is a game changer. In civil jurisdiction, we have principles that secure the right of tribal nations as sovereigns to regulate their lands, including the environment of their lands and their people. So the implications of that case are huge. What about all the oil and gas wells that have been drilled all over? What about the contamination of these companies on tribal land? What about the people who are exposed to that? Can the tribe regulate that? And it just so happens that they knew, I think, that this was coming down the road, because in 2005, there was a midnight rider onto a bill that basically gave Oklahoma the right to ask the EPA to regulate in Indian country if they ever held that this was Indian country, because all of these tribes have treaty reservations that were, for the other tribes, likely not disestablished either, although McGirt, dealt with the creek. So what does that mean? It means that the state is fighting to keep its jurisdiction. And when you look at the quality of the environment out there, and I'll tell you, the first wave of environmental justice claims by tribes was to take the regulatory jurisdiction over their reservations, because that was the dumping ground. They didn't care who they were affecting health and welfare on the reservation. The tribes had to fight for that jurisdiction. And that is what Oklahoma would seek to take away from them with federal authority. So the framework for federally recognized Indian tribes is now protective of their rights to regulate on the reservation. What about off the reservation? Dakota Access Pipeline, Keystone XL Pipeline, maybe that'll get stopped, who knows? Those projects and similar projects pick the Indian communities to run their pipeline next to, it's not through their reservation, it's next to their reservation, affecting their water sources and their traditional territory. That is environmental injustice. And what about the legacy of the past? On the Navajo Nation, there was widespread uranium mining under federal authority for years that has badly contaminated the land, the soil, the water. And of course, you can't get anybody to clean it up because it's so expensive. So that is residual legacy. And the same thing with the coal-fired power plants. There was the highest concentration of coal-fired power plants ever in the country in the Four Corners area. It was deemed to be a national sacrifice area in the late 1970s. Why? Because tribes were there, non-Indians weren't there, and there is widespread contamination. So when Professor Tai talked about the cumulative impacts of this, you saw that with the pandemic. They still don't have electricity or running water in many communities, even though they were feeding the energy needs of Las Vegas and Phoenix and Los Angeles. They were marginalized and excluded from that conversation. And when the pandemic hit, they didn't have the basic resources available. So what does environmental justice mean today? It means taking back that power, food sovereignty, environmental sovereignty, and self-determination under international human rights law. And I could talk at length. I want to be very respectful of my colleagues who have things to say, but the international human rights framework is very important in an era of climate change. These are often transnational communities. The borders are very fluid. What happens in Latin America affects us here. and same thing with the US and Canada and the northern border. So Indigenous peoples, Indigenous land, and these are really core issues for us. So thank you so much.
Thank you so much, Professor Tsosie. Um, Ms. Kyle, Selena Kyle, you're up next.
Hi, everyone. So I'm going to also keep my remarks brief because I really want to hear questions. And I think there's a way for folks to put those in a chat that someone will see and pass on. So please do that. I don't want to just talk. I want to know what people are interested in. But what I was asked to talk about is a couple of lawsuits that I've worked on that are illustrations maybe of ways that communities that I've worked with have responded to environmental issues through impact litigation. One that I'm going to talk about was about a contaminated landfill, in Dixon, Tennessee, which is Eastern Tennessee. The other is about a coal-fired power plant called the E.D. Edwards plant, which is outside Peoria, Illinois. So I'll just give you a little background on each of these, and I have links I'll put in the chat that have some good photos and just more background. The Dixon Landfill, as far as we could tell from our research on the case, was probably originally developed as a town dump in the 40s. Dixon is a town that's on the I-40 between Memphis and Nashville. It's a mostly white town, but it has a neighborhood that's largely Black, and that neighborhood surrounds what is now the municipal landfill site, but which started as basically, I think, an open field where people just come and dump. And we were able to actually find a lot of people who had lived in the neighborhood going back to those times when it was first developed, and remember just playing ball out in that field before it became a dump. We got involved in this case because one of the women who eventually became one of our clients had started investigating some contamination from the landfill herself. Her name is Sheila Holt. She and her mom, Beatrice Holt, are part of a Black family that have a piece of property right next to the landfill. And their private well, a lot of people in that area, it's pretty rural. So some people are on city water, but a lot of people rely on private wells for their drinking water and other home water. Their well had become contaminated, but with trichloroethylene. I'm sure Steph recognizes that, very harmful, toxic chemical. The well was tested, contamination was found there. One of the samples was 5 times the maximum contaminant level for that chemical, which is the regulatory standard that applies in public water systems. And for some reason, they were told that the water was fine to drink, and they kept drinking it. Sheila was later diagnosed with breast cancer, which has been linked to exposure to trichloroethylene. So she started investigating herself, like, why is this happening? What can I do to stop this from happening to other people? At one point in time, contamination was found in a different part of Dixon that was more white. Those people were notified and offered bottled water, but that had not happened to Sheila and her family. And they ended up joining an environmental lawsuit that my organization filed, the Natural Resources Defense Council. We also sued on behalf of some of our own members who live in this town and have wells that they are worried would become contaminated. So we filed a lawsuit under the Resource Conservation and Recovery Act, RCRA. There's a citizen suit provision that allows you to sue to abate disposal of waste that may present an imminent and substantial endangerment to the environment. Somewhat obscure, but very, very powerful provision. And meanwhile, Sheila and Beatrice, and if you go to this link, you'll see there's some photos of Sheila and Beatrice, and actually like a video of Beatrice's deposition in the case, talking about some of her personal history with her family's property. It's pretty powerful. But they were involved in a parallel civil rights lawsuit that they brought with the NAACP Legal Defense Fund that went to failure to notify and discrimination. Our case was about containing and better understanding this contamination. And we ended up settling it shortly before trial for a set of remedies that included basically defining an environmental risk area and then notifying people who were still in well water and paying to get them connected to city water, which is actually can be quite expensive in a rural area. You have to run a long line out to the street. People resist it. So basically like paying to get people connected to city water, capping their wells, and then doing ongoing monitoring to try to keep the contamination from spreading further. That settlement is still going on, but the litigation itself wrapped up wow, I guess about 9 years ago at this point, but it's a very interesting story. So I encourage you to check out the links. The Edwards lawsuit, this is the one about the coal-fired power plant outside Peoria. This settled about 1.5 years ago, and I stepped in as lead counsel on it pretty far into its life. So I wasn't involved at the beginning, and I don't think it was necessarily conceived of as a case about environmental justice issues. But by the time we were litigating the remedy phase, so basically the judge had ruled that this plant had violated the Clean Air Act. They were releasing too much coal ash into the air, and that's very serious. Like, it's fine particulate matter. When there's more in the air, there's more strokes, there's more heart attacks, there's more asthma attacks. It leads to cognitive decline in children and the elderly. Our experts in this case concluded that lives were lost in the area because this plant failed to invest in the modern pollution control they needed to stay under their limits, and instead they just dumped ash on people. So it's a terrible situation. In thinking about whether we could resolve that case or whether we should take it to trial, we thought a lot about the communities right around the plant who are most affected by the pollution and are likely to be most affected by the plant's closure from an economic perspective. The settlement that we reached calls for the plant to close by the end of next year, but it also provides $8.6 million for local projects. And those are in a couple of areas that are connected to the environmental and public health harms from the pollution that we sued over. So there's money for job training programs to account for the closure of the plant and the economic fallout from that. There's money for solar panels on community and school buildings. There's money for lung health education and treatment and medical intervention. There's money for energy efficiency improvements like home weatherization for low-income households. And there's bus electrification funding. And those projects are underway now. Some of them have actually wrapped up. I was there earlier this week to celebrate the rollout of these electric school buses. So the district that includes the coal plant will now have an electric school bus instead of a leased diesel bus. So they will be all electric. They have just one bus, and they will no longer have to pay to lease their bus, which is very helpful because they will lose some property tax revenue when the plant closes. And then a district right across the river from the plant also got an electric school bus, and theirs is bidirectional, which means it can store electricity in its battery, but then feed it back either into the grid or into something else that needs power. So it can be used as like a giant mobile battery, and it can be moved all over town and used to back up like their 911 call center, you know, wherever they need it. I think they're just still figuring that out because they just got it. So that, I think, is an example of a way that even if a case is not conceived of as an environmental justice case and starts as a more sort of classic environmental enforcement case, citizen suit, that it can move in that direction over time. And for this particular settlement, we were very grateful to have community partners advising us about the best way to allocate this funding, and in particular, the best way to really target it to the communities of color and the low-income communities that were closest to the plant, most likely to be affected. So we had the Peoria NAACP chapter. We also had a group called the Illinois People's Action, which works on poverty issues as well as environmental public health issues. And then a third group, the Central Illinois Community Health Alliance, Healthy Community Alliance. So I'll put a link for this one as well if you want to read more about what's in that settlement. My organization has also brought some big enforcement cases under the Safe Drinking Water Act, including the one in Flint, Michigan that you may have read about, and then there's also one in Newark, New Jersey. Those have also been settled recently, and I'm happy to talk a bit more about those. I haven't worked on them personally, but I'm happy to give folks a little bit of an update on where they stand.
Great, thank you so much. Last but not least, we have Hee-Jin Huang to talk about the work done at Lone Star Legal Aid. Thank you.
Thank you, Professor Tai, and thank you, Professor Tsosie and Selena. I've learned so much already just listening from you both. So as Professor Tai said, my name is Hee-Jin Huang, and I work at Lone Star Legal Aid in Houston, Texas. I wanted to just give a little bit of an overview of what legal aid does and who we are, how we work with our communities, and then finally connect back to the point that Professor Tai mentioned earlier about how to apply a critical race theory angle in this environmental justice work. So Lone Star Legal Aid is a legal services corporation. We have a service area of 72 counties in Northeast Texas, and some of which are in Arkansas. The team that I work with, the environmental justice team, is part of a larger equitable development initiative that also includes fair housing and community advocacy. Outside of this unit, but part of the organization, there's also a disaster relief unit that handles flooding issues and that handles a lot of the Texas winter storm problems that Princess had mentioned earlier. Now, having an environmental justice team at a legal aid is definitely somewhat unique, and it was made possible because of the part of the Bank of America settlement in the mortgage crisis in 2014. There was money that went to the state of Texas, and it went to the various legal aids to do this environmental justice and community development work. So it's not just Lone Star Legal Aid in Texas, but Texas Rio Grande Legal Aid and the Legal Aid of Northwest Texas, who each handle their county and service areas and do environmental justice work there. But as the late Luke Cole, who was one of the founders of the Center on Race, Poverty, and the Environment, once wrote in 1994, legal services attorneys have brought environmental justice suits from the very beginning, whether it was challenging pesticides and the impact it had on farm workers in California by California Rural Legal Assistance, or even to stop strip mining on behalf of poor rural residents in Kentucky. There are also cases that the Native Hawaiian Legal Corporation had brought, as well as the South Chicago Legal Clinic's environmental law program. So legal aid has had a long history of being involved in environmental justice, and I feel very lucky to be just a part of that history here with Lone Star Legal Aid. So Lone Star Legal Aid, our environmental justice team handles a large range of matters. And if you've ever even been to Houston, the one city in one county, there are a multitude of issues. And for example, some of the work that we do, we combat environmental nuisances, as well as displacement of residents who live in a residential area by industry through the use of deed restrictions. Houston is a city that does not have zoning. Therefore, it's very common to see a neighborhood where you see a residence right next to an industrial facility or a junkyard or some other nuisance emitting facility. And unfortunately, zoning is not something that Houstonians can rely on. Therefore, one of the projects that we work on with many different neighborhoods includes revising deeds in order to put in restrictions against such problematic uses to preserve the residential characteristic of these neighborhoods. Other work we do, we challenge a lot of air permits that come out in the area, whether they're located in Houston, whether it's a facility located in Port Arthur, whether it's located in Freeport. There are a number of industrial hotspots just in Harris County and the surrounding Jefferson counties and other counties alone. This entails whenever the Texas Environmental Regulatory Agency, TCEQ, issues notices for applications from facilities where they are either seeking a new air permit or seeking to amend an existing permit, then the team will ensure that these permits are in compliance with all the relevant laws and regulations. One of my former colleagues who is now at a different organization, Colin Cox, I have to give him a shout out because he was leading a lot of these air permitting efforts, such that one company said that if you want to get an air permit in Port Arthur, you have to go through Lone Star Legal Aid. So what seems like potentially a very simple process, just going permit by permit. And of course, that can be challenging in itself because there are so many permits. But holding companies accountable through these permit actions can actually yield great change. We also work, there's a Title VI case that we had been working on. So for those who may not know, Title VI of the Civil Rights Act requires agencies to ensure that their funding recipients are not discriminating on the basis of race, color, or national origin. One of the cases that we had worked on was in Freeport, Texas, where the port was basically acquiring property in order to expand its operations, but doing so in a discriminatory manner, where they were targeting the East End neighborhood of Freeport, the historically African-American neighborhood, and not complying with the applicable federal statutes and requirements. So this is a case where it's currently on appeal in the Fifth Circuit, and we're waiting to get a decision. But some of our work entails litigation that also gets to the Fifth Circuit. Another aspect that I wanted to highlight of our work is we have recently been working with one community to broaden language access in TCEQ's participation requirements. And this is because we've highlighted how environmental justice impacts Black communities, how it impacts Indigenous peoples, and it also impacts other people of color, including those who are bilingual or limited English speakers, Latinx, et cetera. And what we see in our service areas often, particularly in Houston or in Pasadena, is that these industrial facilities and hubs are located right next to communities of color. Yet there are not protections in place where these communities can be adequately notified of the different industrial activity that is undergoing review right in their neighborhoods. There is not a great system where they can participate and make sure that they are heard, because there are no mandatory interpretation requirements or translation requirements. So this is actually something that is currently under rulemaking in Texas, and these efforts were brought about in large part because of a community organization on the ground, Tejas, as well as the Sierra Club. So broad range of issues we work on. And one of the questions that I wanted to answer also was, how is it that we partner with these communities? And as I mentioned earlier, if you are in the city of Houston, then you know that these problems are everywhere. But the unique thing also, I think, in working with the various communities is just learning the history of many of these communities. For example, we work in Barrett Station, which was founded by Mr. Harrison Barrett, who had been formerly enslaved. We, again, like I mentioned, worked in Freeport and the East End neighborhood, which was historically segregated by city ordinance. We work in Pasadena, where the city had been sued for intentionally discriminating against Hispanic voters. These issues are everywhere, and the communities themselves have experienced injustices over and over and over again. They have lived right next to these facilities for generations. They are acutely aware of the impacts and the health harms that they themselves and their communities have suffered. And so the communities are really the experts. And we try to make sure that the communities are put first, whether it is by going to community meetings, not on a specific issue that we want to work on, but just because we're trying to build those relationships. Some of that has been impeded, unfortunately, in COVID times because there are less in-person meetings. Thankfully, many groups have been able to transition to Zoom and use these online formats, but there are definitely some challenges there. But just working with communities, eventually building those relationships over time, then that trust relationship is there, and our clients will raise various issues with us. Now, oh, I'm sorry, Professor Tai.
No. I was just, sorry. I thought you were finished, but I wasn't sure. Sorry.
Oh, I did want to touch on that last point about CRT, if that's okay.
Yes, go ahead.
Great. So I think the important thing about critical race theory, and I was part of the critical race studies program at UCLA, you learn that the power is of CRT is that it gives you the terminology to express the injustices you already know exist. And you learn to be a little skeptical of terms like race neutrality and colorblindness, because you do a systematic review of the history and the case law, and you see that those terms were used not to further equality or equity, but really to cover up existing inequality. So I think the most important thing is just having that knowledge, and then it makes an advocate more relentless in questioning case law and really digging in to make sure that what the law says is really what the law says. And I guess one thing I wanted to highlight is, for example, the Texas Environmental Agency has this standard language when it's evaluating air permits, where it says that air permits are evaluated by the agency without reference to the socioeconomic or racial status of the surrounding community. And in their terms, that is having considered disproportionate impacts. Now, if you have studied CRT or really just dug into the disparate impact law or intentional discrimination law, I think immediately there's a red flag there saying, how is this saying that you have actually conducted a racial disproportionate impact analysis? So I think that's just one area that I wanted to highlight, but there are so many other areas.
Thank you so much. That was a really great presentation, and I'm glad you got to that point. I'm sorry that I interrupted. I just wasn't really sure, but that was really great. Thank you. We have about 13 minutes left for questions. So I'm going to bundle up. So we have 4 questions right now. I'm going to bundle up 2 at once that are similar to me, and then I'll bundle up 2 other ones. You can keep typing things in and hopefully we can get to them. I'm going to just ask people to try to answer quickly if you can. So 2 questions that seem similar to me. Can anyone discuss any movement towards increased oversight over the effects of marginalized communities living near power lines, non-potable water sources, poisoned water tables? And can someone speak about the current issues concerning food deserts in communities of color, or any efforts to remedy this systemic problem? Any of you should jump in if you want to answer.
I can speak to the first one a little bit. Another case that I have right now is under the Toxic Substances Control Act, TSCA. It's another one of these kind of lesser used like federal environmental laws, but it was actually amended in 2016, and it has some new language in it that's pretty powerful that's now being tested in the courts for the first time. But basically, the part that we've sued to enforce requires EPA to do these comprehensive evaluations of the risks that are presented by different chemicals. Our case is about methylene chloride, which is another one I'm sure Steph knows a lot about. But they're supposed to look at the whole life cycle of chemical, who makes it, how is it used, how is it disposed, right? And how does that affect people over the country? So they had deadlines, EPA had deadlines to start issuing these risk evaluations for different chemicals under the Trump administration. They started coming out at the end of 2020. And EPA did a terrible job with the methylene chloride risk evaluation. Among other things, EPA decided to ignore all releases of the chemical to ambient air, water, and soil. They just looked at interior settings and uses in particular products. And those things, of course, are very important, right? Like when you're thinking about something like worker exposures, but they're not the whole picture. So they basically just waved their hands and said, there's other environmental laws that deal with that pollution. Meanwhile, of course, the chemical is still being made and released, from hazardous waste recyclers all over the country. We have a Chicago-based environmental justice group called Neighbors for Environmental Justice as one of our clients in this case. They're a pretty new group based in McKinley Park. They're awesome. I'll put their website in the chat here too. But they got involved because their group at the edge of McKinley Park is one of these big hazardous waste recyclers that emits methylene chloride. It was actually the subject of an enforcement action by EPA a few years ago that had to do with leaks of this chemical from the tanks. That was settled with no notice to the community. But anyway, EPA's new study doesn't look at sources like that of the chemicals, even though TSCA, the Toxic Substances Control Act, now says that these risk evaluations have to look in particular at the effects on potentially exposed and susceptible subpopulations. Kind of weird language, but potentially exposed and susceptible subpopulations. The legislative history says that means people who are more vulnerable to this chemical, either because they're exposed to more of it or because they have some special susceptibility, for example, like a genetic sensitivity to the chemical that makes them more likely to get cancer if they have a particular amount that they're exposed to, which also happens for methylene chloride. And we hope that the court will take that language seriously and hold EPA accountable for ignoring it. And that in the future, when EPA does these risk evaluations or revises them, it will have to study in particular, what happens to the communities who live around these emitters and what risks do these chemical releases present to them in particular. And that's very important because if EPA concludes after doing one of these risk evaluations that the chemical presents an unreasonable risk to health or the environment, they're required to eliminate that risk through further regulation, which is pretty unusual. So they cannot let an unreasonable risk persist. Once they find it, they have to eliminate through future regulation. And so we're hopeful that the litigation will succeed and they will expand their risk evaluations to account for effects on neighboring communities, as well as everything else that they ignored or understated, as the case may be.
Great, thank you so much. I'm going to talk to the food deserts kind of issue because there's two different main ways that I've seen this be developed. So I've worked with folks who are community developers in Detroit, and what they've been doing is sort of trying to get grants to just buy up brownfields and use them as sort of areas for urban agriculture and to use sort of SNAP funds to actually distribute some of the products of this. So this is a sort of urban way to try to address some of these kinds of food deserts. But at the same time, there's a lot of really exciting sort of indigenous agriculture efforts that are going on. I'm going to just sort of give a shout out to the Great Lakes Indigenous Law Center, which is at my law school, and folks there who are working on helping tribes get grants to increase sort of indigenous sort of agricultural efforts and to sort of move, because there's many sort of food deserts in a lot of like reservation lands, as Professor Tsosie probably knows. And so, these kinds of efforts are ways to try to address food deserts, both in sort of urban areas, as I mentioned with Detroit, and these are examples of how to sort of do this in sort of reservation areas. So that's a quick answer to that. I'm going to move on just to try to get through these questions. We also have two very land use related questions, so I'll ask them together. Do you believe that redlining was influenced by environmental injustice or vice versa? And also, could someone speak on environmental gentrification and how this is occurring in different cities? Any thoughts?
I could speak a little bit to the second question about environmental gentrification. It's definitely something you see in our service area. And as I was talking about the de-restriction projects that we're involved with, some of the issue is, again, a company gets an application and cites a facility right next to a residential neighborhood, and then all of a sudden it becomes an industrial hub. Therefore, anyone who used to live there no longer wants to live there, or they're facing displacement because of the health impacts, or it's just a really terrible place to be. And so that's definitely something we've seen a lot of, and something using deed restrictions is partly a way to combat against. Something we also see, unfortunately, is flooding being used as, not being used as, but it can become a pathway for displacement and then gentrification, because you see that floods here, at least in Houston, impact a lot of the low-income neighborhoods, the historically Black neighborhoods, and unfortunately, the way that the flood relief funds have been distributed take a very long time, or they have yet to be distributed. So some people leave, some people remain in moldy homes, but eventually, I think when people leave those properties, then they are torn down and then something else comes there. And so the original character of that neighborhood is also has begun to disappear. So I think just being aware that these impacts occur and that gentrification takes on many forms is really important so that we can be aware and come up with solutions that are appropriate for these various communities to try and combat that gentrification.
Really thoughtful, thank you. Anyone have any thoughts on the redlining question?
So just a brief comment on that. I do think that the historical part of what has happened to, you know, African American and Indigenous and other marginalized communities, it's the result of official discrimination, and that's really what redlining was. But the consequences today, as Heejin just said, today we're seeing sort of the economic theory about, you know, rebuild after a flood. Well, the environmental justice communities that we're talking about, they can't rebuild without the funds, and if the funds don't get to them. So the economics of that, it's still a form of official discrimination. It's just that we don't call it that because it's based on economics and these other neutral factors. And so the critical race theory lens is really what you look at that says, you know, contemporary forms of discrimination are built on the past forms. And even though they're technically neutral today, they're not, because the impact is still the same. So that's just how I see it.
That's a great answer. Thank you. So I think we have time for just two more questions, and there are two more questions. So one is a more sort of positive question. Are there any ways that we as law students can increase awareness of these issues? And then the other one is a more, you know, pessimistic question. Are you concerned about the viability of courts as an avenue for remedy with all of the judges appointed by President Trump? I'll leave these up to you guys to answer.
I'll take a stab. So I will just say yes to the question about judges. It's concerning. I try not to think about it too much. It's very concerning. I think something that I've found really effective in my practice is just calling attention to what's happening. I think especially in a large urban area like Chicago, it can be hard to lose sight of what's happening in certain neighborhoods, which connects to the zoning piece. I don't know much about redlining in particular, but certainly in Chicago, there's been a pattern of concentrating the heavy industry, the dirty industry in certain parts of town. And there's a big controversy right now that led to a hunger strike that just ended. Actually, it went on for a month, but it has to do with a scrapper, auto shredder, that's trying to relocate from the edge of my neighborhood, Old Town Lincoln Park, which is largely white, wealthy neighborhood on the north side of downtown. They're trying to relocate next to a bunch of other scrap yards that are owned by the same company on the south side. And in my experience with this kind of work, it's very effective to just kind of hold a mirror up, you know, and show everybody who lives in Chicago, like, look what's happening in your community. Look what's happening to people in this other neighborhood. Is this the kind of city you want to live in? Is this something that makes you proud? And I think that just encouraging people to see it and think about it and think about what it would be like to live next to certain kinds of facilities and try to put themselves in the shoes of people who do can be really powerful and effective.
Thank you. Any other thoughts? I think definitely, you know, raising the visibility of this is really, really important. And I'm glad you talked about this, but also just, you know, I think not just raising the visibility in terms of this, but also I think amplifying the voices of people on the ground to the extent that you hear communities sort of have outrage about environmental injustices. Try to promote their voices too. And I think that that's something that we often forget about. We think of lawyers as swooping in as saviors and stuff like that, but we are also amplifiers. We can also do things like, you know, help give litigation support for people who are protesting, right? People who are protesting often need sort of lawyer observers, all of that stuff. And these are things that we can do as lawyers that extend beyond what we think of oftentimes as the role of environmental attorneys, but just as attorneys providing supports for communities in need. And I think that's something that we can do as well. I think our time is up, but no one seems to be stopping us. Yeah, let's go.
I did also want to add, you know, I agree with what Selena was saying, but at the same time, there are other opportunities to advocate outside of federal court. And sometimes litigation is not even, you know, the first step that we want to take. So I think there are lots of opportunities to do environmental justice advocacy, and then hopefully going up to a court with a Trump appointee will be the last thing that has to happen.
And there's always state legislators.
Exactly.
There's also, just actually working with companies themselves, like the Fair Food Movement, which is one so the Coalition for Imkali Workers has dealt with basically environmental injustices for tomato farmers, right? Tomato farm workers for a while. And they did a whole public kind of grassroots campaign rally against people sort of fighting for fair pay for tomato workers. And that actually got a lot of buy-in from sort of national purchasers of tomatoes. So, even if the federal judges are stacked against you, there's state judges, there's state legislators, there's federal legislators, and there's actually private industry itself. There's all sorts of arenas to work in. And I hope we do it all. I now got a notice saying where time is up. So, yep, I'm bringing the conversation to a close. I'm doing it. Thank you, everyone. Please give a loud applause, even though this is a webinar thing and no one's going to hear this. I'll do it for all the great speakers today. Thank you very much. And thank you for attending this wonderful event.
Thank you.
Thank you so much.
Thank you. Yes. Yeah. Thank you.